Hi everyone, Kenny Chan here with Prosenco Group Century 21. For this video, we're actually going to not talk specifically about real estate update, but for the first time, I'm actually going to review with you a legal case and go over it. This more specific topic is going to be about the forfeiture of deposit after a buyer fails to close. So obviously, I am not a lawyer, so most of the stuff that I'm going to talk about, I will be basically copy pasting from the actual legal case itself. If you ever want to look it up, it's just this citation, court file, and the date that this was all done. So let's give a little bit of background in terms of this case between the buyer and the seller. So the buyer and seller entered into an APS, which is Agreement of Purchase and Sale, to purchase a property on November 25th, 2019. The purchase price for the property was $1.41 million. Okay. The buyer put down a $100,000 deposit, and it's currently held in trust by the seller's brokerage, Remax. The closing date was February 28th, 2020. The day before closing, the buyer advised the seller through the buyer's lawyer that the buyer was unable to complete the purchase and that the buyer wanted to terminate the agreement of purchase and sale. On the closing date, the seller was ready, willing, and able to close the transaction. The seller estimated that their damages suffered as a result of the failure to close amounted to $11,000. So this could, basically that $11,000 could have been calculated from marketing fees, mortgage interest, condo fees, all that kind of stuff, all right, as well as time. So then after that, within 2 weeks after the failed transaction, the seller entered into a brand new agreement of purchase and sale with a different buyer, and then they sold the property for $1.525 million. So you can see here, the property was originally sold $1.41 with a deposit of $100 from buyer number one. Buyer number one could not close. Seller sold it to buyer number two for $1.525 million. So here's the question, the legal question. The seller wants the buyer to forfeit their deposit. The buyer wants their deposit back because the seller resold the property for more than what the buyer offered. So therefore, if the seller kept the deposit, the seller would have an unconscionable windfall, which is the terminology used in the legal case. So my question to you, and think about it for 5 seconds, is what should happen to the deposit? All right. So once again, I'm not a lawyer, but I will go through as best I can what the summary of the legal case was and take out certain quotes. Obviously, don't ask me if you have legal questions. I'll probably ask you to ask a real estate lawyer. Okay, so let's go through the judge's reasoning. But so this whole sentence here, which you can read, is basically saying that the deposit is placed to encourage the buyer to close the property, right? And they worded it here, it is separate from the principal contract, and it is intended to show that the buyer is serious. So the deposit shows the seller that A, the buyer has money, but also that the seller should not worry too much about the buyer's kind of background or credit worthiness, especially if the deposit is quite large. That is a signal from the buyer to the seller that the buyer is financially capable and ready to close this transaction. The next thing is, okay, the $100,000, is that a too large of a deposit to forfeit? So when we calculated it, or when the judge calculated it, 100 over 1.4 mil is 7%. And generally speaking, the courts seem to recognize that a deposit of 10% is customary and can be validly forfeited. So obviously there have been some cases where the deposit was 20%, in which case maybe the deposit was disproportionate to a reasonable amount, but that's a different story for a different day. So the judge also then said that I do not agree that there has been an unconscionable windfall in this case. The seller has made a profit that the buyer may also have made and therefore come into an unexpected profit. However, the seller could have equally lost money. To some, this may be a windfall. The seller was certainly fortunate, but nothing about the seller's conduct or position is unconscionable. So before we go into lessons learned, you can kind of see what the judge is looking at here, right? The judge is basically saying, well, this deposit is placed in good faith by the buyer with the idea that really, at the end of the day, if the buyer fails to uphold their end of the contract, they should forfeit their deposit and potentially even more. Then the second thing to mention is that the deposit itself is not a significantly large deposit to begin with, so they don't see it as out of ordinary for a forfeitable deposit. Then secondly, they said at the end of the day, the seller could have lost money after. Anything can happen after a property is sold. Price could go up, price could go down. since the price had gone up, the buyer would have actually had, if the buyer was able to close, they would have actually had a potential for a future profit. But buyer could not close, and now the seller gets that profit. And they're saying that the seller's position is not considered unconscionable. So lessons learned. All buyers should take every possible avenue to fulfill their contractual obligations. So if there's an issue with financing, maybe you have to get a guarantor. Maybe you have to add another person on the mortgage. Maybe you need to borrow some more money from friends and family, because at the end of the day, as the judge has said, the deposits are routinely forfeited if the buyer is unable to fill their obligations. If you have any questions, not about this case particularly, but just about real estate in general, my information is below. And I hope to reach out to you if you have any questions. See you later. See you at the next one. Bye now.